Hello everyone, and welcome to episode 66 of the FCPA Compliance and Ethics Report. Today I'm pleased to have back the FCPA professor. In this episode he's going to talk about his views on the Esquenazi decision, his recent book, and his upcoming FCPA Institute. I hope you enjoy the episode. Thank you.
Hello everyone, this is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. It's my distinct pleasure to have my good friend and colleague Mike Kaler back with us, the FCPA professor. We're going to go with Mike today because it's summer and you're off not professing, at least today, although you obviously are writing and researching, and you've got a couple of interesting things to talk about along that line. But we haven't had a chance to visit this year, and I've been haranguing you to join us, and now is as good a time as any, so thanks again for coming on.
Thanks for having me, Tom. It's always a pleasure to chat with you.
As usual, no matter when we think the FCPA is dying down or things aren't happening or FCPA Inc. may need some new things to write about, something pops up for us to chat about. And in our world, certainly one of the biggest things that has happened in the last 30 days is the Esquenazi decision out of the 11th Circuit Court of Appeals in the southeastern part of the United States. And I know we've both written about it. I think you had some tangential involvement in it, maybe even direct involvement. But it's certainly big in our world, so I wanted to ask you to come on and give me your thoughts on the opinion and where you think it may go from here. So with that introduction, let's just go. You've given me some of the things that you would like to highlight. But I guess interestingly, what did you think Esquenazi stood for, what it didn't stand for, what it looked at? So please have at it.
Yeah, and just by way of background, of course, the FCPA community, the compliance community, has been anxiously awaiting this decision really for the last year and a half, 2 years, because it was the first time in FCPA history in which an appellate court had the opportunity to directly address the enforcement theory that employees of alleged state-owned or state-controlled companies are foreign officials under the FCPA. And just to give the appropriate disclosures, if you will, not only this foreign official challenge, but some of the other trial court challenges were based in part on my so-called foreign official declaration, a rather meaty 150-page document or so that talks in great detail about the FCPA's legislative history. I was engaged in an expert in those trial court challenges and provided pro bono expert assistance to defense counsel in this Esquenazi Rodriguez case to lawyers who were also handling the case pro bono. I think it's important to understand what was at issue in this case and also what was not at issue. Let's start with the what was not at issue. What was not at issue was what the FCPA should look like. What was not at issue was whether the FCPA should be a comprehensive anti-bribery statute, for instance, like the UK Bribery Act. What was not at issue was what practical effect, if any, this would have on corporate compliance programs. But what was at issue was what I will submit is the very basic fundamental concept that when the government marshals its full resources against an individual in a criminal action and deprives that individual of his liberty, what was at issue is to make sure that as to each element of the crime alleged, that element is being interpreted consistent with the intent of the statute. And that's a very basic concept, given that the Department of Justice and the SEC can only enforce a statute that Congress intended to pass. And by now, we know what the 11th Circuit concluded that the term instrumentality in the FCPA's foreign official definition can encompass, in certain situations, alleged state-owned or state-controlled entities such that the employees of those entities are foreign officials under the FCPA. So the Department of Justice did prevail. The 11th Circuit did affirm the convictions of Esquenazi and Rodriguez. But I also think it's important to recognize that this is an appellate court decision, the first one, but just one appellate court decision. And some of the commentary I've read since the decision suggests, in my mind, wrongly, that, oh, this issue is now resolved. Well, can anyone show me another area of law in which a disputed legal issue is viewed as being resolved or settled just because one appellate court has issued a decision? Now, I don't suspect there will be another foreign official challenge in a while, because when you really think about it, the stars need to align, and the stars did align, really, in terms of some of these foreign official challenges in the following ways. First of all, an enforcement action has to allege this theory, which many do. Second, you have a situation in which the defendants are willing to test their innocence, which very few criminal defendants are because of the pressures to plea to get a lower sentence. You then have to have the financial wherewithal or the ability to attract pro bono counsel. So it's pretty amazing when you think about it that it took 35 odd years for us to get this first decision on this issue.
You're certainly correct that it's taken a long time, but my concern is, and I would echo, if you're not an explicit statement, certainly your implicit statement, that further judicial scrutiny and commentary on the FCPA is certainly welcome, because we both believe it's something that is needed to have courts weigh in to fleshing it out. But since it took so long to get this first decision on something that has been advocated by the Department of Justice for at least since maybe 2000, certainly 2004, I wonder how long it's going to take to get another circuit court or court of appeals to weigh in, because in addition to all of the other factors you listed, the case has to go up on appeal.
Right.
And so there are 10 other circuits out there, and I've kind of racked my brain since Esquenazi, and I can't think of a case in the pipeline that we're aware of, criminal case, that this issue could be raised. The only cases I can think of that I'm aware of are the Petro Tiger CEO case and the SEC civil actions here in Houston around the Nigerian or against Noble executives, and I'm not sure if that issue is in that case or not. But are you aware of any other cases where it could at least percolate up?
Yeah, in terms of the SEC case against the Noble executives, my understanding is those foreign officials are with the Nigerian Customs Service, so that the foreign official issue is really not directly at issue there. Right. I do believe that there's an additional Alstom executive that has not pled yet, and that case is at least proceeding to trial, and that case concerns a power plant in Indonesia. You know, I also think it's important to recognize the following. Some commentators have suggested that, you know, people, and I guess I'll take that personally since I was involved in some of these cases, need to pick and choose where they choose to challenge the department more wisely. Well, I mean, I'm not going to apologize one iota for my involvement in these cases. And let's remember this, the legislative history says what it says, and not the 11th Circuit had a flawed analysis when it came to the legislative history, which I can get to in a second. But let's just take a step back and look at what happened in some of these other foreign official challenges. John Joseph O'Shea challenged the foreign official theory in the Southern District of Texas. And that case, he was acquitted after the DOJ's case on a number of areas, but counsel in that case will tell you that that foreign official challenge framed the issues in such a way, and the transcript is clear in that case, that the judge was troubled by the DOJ's foreign official interpretation, even though the judge was not willing at the pretrial phase to dismiss the complaint. The Carson case, obviously the judge in that case denied the pretrial motion to dismiss, but let's not forget the judge issued a very pro-defendant foreign official jury instruction, which basically said that the defendants had to have knowledge that the person was a foreign official. And very soon after that jury instruction, the DOJ came in with what could only be called very lenient plea deals that the risk-averse defendants chose. In the Lindsay manufacturing case, we all know that that case was dismissed because of various instances of prosecutorial misconduct, not suggesting that was directly related to foreign official issues. But we've had 4 foreign official challenges thus far, and yes, we're talking about Esquenazi, and yes, the 11th Circuit decision is what it is, but I'm not so certain that these challenges have been as unfruitful as many people are suggesting. The outcomes of the other 3 cases are what they are.
Well, I would have to say that if anyone said that you need to pick and choose your fights with the DOJ better, I would say that person's not a very good lawyer. You pick and choose your fights because of your clients and the issues that you choose, and to suggest at all that this was not a fight for you to be a part of, I think is very poor commentary on somebody's part. But even if you were going to pick and choose your fights, since you don't get to pick and choose too many of these, you got to get involved in the ones that are important to you. This was obviously important to you. I think you worked with some very good lawyers, certainly at the ones I know at the appellate level of this case, and that had to be professionally a very fulfilling experience for you.
Yeah, I mean, I'll just share this. Approximately 3 years ago, Joel Esquenazi called me up and said, "Can you help?" And I wasn't prepared to take the appeal, but I was confident that I could arrange for some lawyers I had confidence in and trusted to help out on this matter. Before he reported to prison, Carlos Rodriguez called me up and asked me the same question. And I had the same answer that I was willing to help. Regardless of what one may think of an individual in an FCPA enforcement action, at the end of the day, these are real people with real families. And it's so fundamental to the rule of law in our system of justice that when one is deprived of their liberty, we need to make darn sure that the balls and strikes are being called fairly, and that statutes are being interpreted and enforced in a way that is consistent with congressional intent. And I know the 11th Circuit has spoken on this issue. Where that leaves Mr. Esquenazi or Mr. Rodriguez remains to be seen. They're obviously still in federal prison. But let's call a spade here and recognize that without individuals, there would not be one iota of FCPA case law. None. So I think regardless of what these individuals were found guilty of, it's a courageous step for a person to test their innocence. And without these individuals and some other individuals throughout FCPA history testing their innocence, we won't know anything about foreign official. We won't know anything about obtain or retain business. We won't know anything about knowledge. So let's just not forget that point.
And I think it's the role of a lawyer to take those cases on as well. So as a Southerner, I always have to tip my hat to Atticus Finch. So he may be rolling over his grave over GM, but the way you articulated that, I think he would certainly second your notion of the role of counsel in any of these questions. You mentioned you had some criticisms of the opinion. Could you share those with us?
Yeah. Obviously, my role in these cases and challenges was legislative history, and the legislative history is what it is. I've spent in excess of 250 hours immersed in the FCPA's legislative history, and if anyone wants to spend that amount of time in the legislative history, go right ahead and let's have a conversation and compare notes. The salient regarding the FCPA's legislative history are as follows. Congress was well aware that some of the problematic payments that were discovered in the mid-1970s were to SOE employees. Certain of the other bills that Congress considered when finally enacting the FCPA contained a definition of foreign government that explicitly included SOE concepts. The ABA even provided Congress with more explicit definitions as to SOE concepts. But despite being aware of SOEs and despite being able to articulate SOE concepts explicitly in some of these other bills, the end result, the FCPA that was actually passed in 1977, contained no explicit reference to SOEs. Now, the 11th Circuit did not even consider, at least in terms of its written opinion, who knows what they considered in chambers or during their deliberations, any of this enacting legislative history. The only legislative history that the 11th Circuit talked about was the legislative history in 1998. That was flawed in that it's abundantly clear that if you do a legislative history analysis, the only important legislative history is the enacting legislative history. Subsequent legislative history is really irrelevant when giving meaning to a term that was previously part of a statute. But what the 11th Circuit did and why they looked at the 98 legislative history is it included this public national organization prong to the Foreign Corrupt Practices Act. That additional prong as to the foreign official definition that was added in 1998 is really completely separate and distinct from the enacting legislative history, which contained the term department, agency, or instrumentality. And the 11th Circuit knew that it was on thin ice in doing it. It even almost apologized in the opinion and actually said that it's hazardous to look at subsequent legislative history, but they were going to do it again. Another flaw with the 11th Circuit's opinion is this whole concept that because the United States signed on to the OECD convention, that somehow, through a process I'll call osmosis, that somehow the FCPA automatically changed just because the U.S. signed on to the OECD convention. First of all, the OECD convention was not a self-executing treaty. All it said was that countries should take measures to conform their laws to the basic thrust and spirit of the OECD convention. So the 11th Circuit said, well, our conclusion is further bolstered by the fact that the OECD embodies, encompasses SOEs. But merely by articulating those words, Congress did not change the FCPA. The only way that Congress can change the FCPA is actually by changing the statute. And following the 11th Circuit's reasoning, are we supposed to now assume that the FCPA does not contain a facilitation payments exception? Because the OECD doesn't contain an express one. Are we to assume that the FCPA no longer applies to payments to political parties? Because the OECD excludes political parties from its coverage. So that's another flaw in the 11th Circuit's reasoning, I think. This whole concept that because the United States signed on to the OECD convention in 1998, that somehow, through a process of perhaps osmosis, changed the coverage of the OEC of the FCPA.
Do you see any chance that this could be further appealed to the Supreme Court?
And there's always a chance, but I think that's unlikely, as you and no doubt your viewers know, the Supreme Court decides its own docket. And while I'm sure there have been situations in which the Supreme Court will take up a case based upon one appellate decision, as you probably know, the Supreme Court generally likes to see circuit splits before taking an appeal. But at the end of the day, whether a petition for cert is filed with the Supreme Court is going to be up to the lawyers in the case, and we'll see what happens on that score. Another thing that is left completely unanswered in the 11th Circuit's decision is if instrumentality can include SOEs, then why do laws enacted before the FCPA, the Foreign Sovereign Immunities Act, and why do laws enacted after the FCPA, among others the Dodd-Frank Act, why do those laws include both the term instrumentality as well as the term state-owned or state-controlled enterprise? There's a maxim of statutory construction that Congress is presumed not to use redundant words. So if instrumentality means SOE, why do laws passed before the FCPA and why do laws passed after the FCPA contain SOE concepts in addition to the term instrumentality? That wasn't discussed in the 11th Circuit opinion.
We'll turn our subject or our topics to a couple of other things now, if we could. One pretty exciting event, I would have to say, involving yourself, and another event that you've got coming up in July. And what I would call a pretty exciting event is finally your book has been released here in the United States. And could you tell us about how you came about it, what it's about,
Yes.
and why somebody should buy it?
It's official, the Foreign Corrupt Practices Act in a New Era. This has been an ongoing project of mine. I write daily on the FCPA, going on now for 5 years, but putting this all into a book finally has happened. This is really a comprehensive and candid and at times provocative view and analysis of the Foreign Corrupt Practices Act in this new era. What readers will find in the 9 chapters of this book are legal authority, i.e. Statutory text, legislative history, judicial opinions, discussion of over 70 enforcement actions, enforcement agency guidance, but also topics that you don't often see written about, and that is really the overall financial impact of FCPA scrutiny and enforcement. The whole concept of pre-enforcement action, professional fees and expenses, post-enforcement action, professional fees and expenses. There's a particular chapter devoted to the origins of FCPA enforcement actions. Among other questions that are asked is why has FCPA enforcement generally trended upward? The book ends with suggestions to improve the FCPA. And then, of course, there's an entire chapter devoted to compliance and best practices and how to conduct a risk assessment. And I've gotten some very positive endorsement quotes from leading commentators, and including former Attorney General Michael Mukasey, who has positively endorsed the book. And it's really intended for a broad audience. I think readers from the boardroom to the courtroom and to the classroom will find benefit in the book and the voice I'm able to bring to the conversation, and to write as an academic in one sense, but yet a person who was in the field for over 10 years and who has sat across the table from DOJ and SEC enforcement attorneys, and really talk about the FCPA, I think, in a way that is not frequently talked about, given the limitations that others sometimes have when talking about this sensitive topic.
Where would someone find it, Mike?
Well, I can find it in a number of places. I just posted about it yesterday on my website, fcpaprofessor.com. It's widely available on Amazon, and the publisher is Edward Ulger, and you can obtain it at that website as well.
Well, I'm looking forward to getting my copy, and I will certainly be writing about it in my blog. So, very interesting. I think it will be of wide and great use to anyone in the field, and as you said, from the courtroom to the classroom and to the corporate boardroom, so and everybody in between. So, looking forward to that, and kudos and tip of the hat for getting your book published. I know what a big project those are, and I know how hard you worked on that. But you've also got something else coming up this summer that I wanted to visit with you about, which is the FCPA Institute. That's I know something that you've also had in the works for some time, so why don't you tell us about that?
Yeah, the FCPA Institute will be held July 16th through the 17th in Milwaukee, Wisconsin. It's my inaugural event. And what the FCPA Institute is, it's an intense 2-day learning experience suitable for a wide variety of professionals who are really looking to, roll up their sleeves, spend some time in a classroom-like environment, doing nothing other than learning about the FCPA, FCPA enforcement, FCPA compliance best practices, so on and so forth. Registration thus far has been good. There will be lawyers really from all over the world attending the event, including in-house and compliance professionals from many leading companies. What makes this unique, I think, is participation is capped at 30 participants. You're not going to be a face in the crowd at the FCPA Institute, but you will get some individualized, hands-on, meaningful engagements as to questions you may have. And learners are going to have their knowledge assessed at the end of the FCPA Institute, and thereby can earn a certificate of completion that I think can be a valuable asset in terms of professional development. Obviously, there are other FCPA conferences or seminars out there, but I think this one is unique in the small classroom-like environment, the focus on learning. You will not hear at the FCPA Institute, well, we need to move on to our next panel. There are no panels. The information is presented in a cohesive, coherent environment by me, a person with FCPA practice experience and with teaching experience. We will be using videos to engage in FCPA risk assessment exercises and issue spotting. And I'm really looking forward to it. It's the first event, but I hope to hold similar events like this in select cities across the country at various points in the year.
If someone wanted to find out more information on it, where would they go?
Once again, my FCPAprofessor.com website. You'll see at the top a specific tab for the FCPA Institute. And again, it's July 16th through the 17th in Milwaukee. And again, participation is capped at 30, and there are still some spots left. So you can sign up via that website, or can email me as well at fcpaprofessor@gmail.com.
Well, Mike, we're at the end of our time. I really appreciate you taking the time to visit with me today. It's been far too long. We really need to do this at least quarterly. Got too much going on not to talk about. So thanks again, and we look forward to our next chat.
All right. Thank you, Tom.
This concludes this episode of the FCPA Compliance and Ethics Report. If you need more information, please contact me at tfox@tfoxfile.com. I hope you enjoyed this episode and you return for others. Thank you.